When the legislature passed a sweeping overhaul of Oklahoma's workers' compensation system 3 years ago, supporters hailed it as a much-needed and long overdue reform. But this week, the state Supreme Court struck down a core provision of the new law, leaving many companies scrambling to provide coverage for their employees.
When lawmakers approved the Administrative Workers' Compensation Act during the 2013 legislative session, one of its more controversial aspects was a provision that would let Oklahoma companies opt out of the state system and write their own plans instead. Several dozen Oklahoma companies adopted alternate systems, which workers' comp attorney Bob Burke says often excluded types of injuries that are covered by the state system.
No tornado injuries or deaths in Oklahoma. It doesn't cover cumulative trauma claims like carpal tunnel. Regular workers' comp does. Doesn't cover exposure to mold. Doesn't cover asbestosis. Doesn't cover any injury for which you've had a previous surgery unless that surgery made you whole.
This week, the Oklahoma Supreme Court ruled the opt-out provision is an unconstitutional special law that doesn't guarantee all workers have the same rights. In the case of Johnny Vasquez, who was injured 2 years ago while on the job at clothing retailer Dillard's, the court found the Dillard's plan violated her rights when it denied her claim. Writing for the majority, Supreme Court Justice Joseph Watt concluded injured workers under the Opt-out Act have no protection to the coverage, process, or procedure afforded their fellow employees falling under the Administrative Workers' Compensation Act. State Representative John Echols is disappointed by the court's ruling, saying it could have simply struck down provisions of the option plan that violated the statute. He also believes calling the provision opt-out is incorrect.
It is somewhat concerning that the court would call the Oklahoma option opt-out. That's politically charged language, and it's not opt-out. I mean, it's concerning either they don't understand the difference between opt-out and the Oklahoma option, or that they were just using the politically charged language.
Jonathan Buxton is Senior Vice President of Government Affairs for the State Chamber, which helped to craft the law.
Oklahoma, the alternative coverage, the Oklahoma option, as some people refer to it as, really requires employers to go in and provide like benefits through an insurance program that they have. It just allows them to opt out of the administrative work comp hearing processes.
Buxton says while the Oklahoma option has been declared unconstitutional, he maintains the overhaul of Oklahoma's workers' compensation system has been a success, pointing out that under the old system, premium costs kept rising.
But every year, as the cost went up, employee outcomes were going down. We were one of the worst states as far as having an injured worker recover, get the medical treatment they need, and get back to work. It wasn't working.
Echols notes the opt-out provision of workers' comp is only one small part of a much bigger picture.
It's important to understand this was a major overhaul. This was a huge shift. And again, the reforms are working. For the fourth year in a row, workers' compensation insurance has gone down in the state of Oklahoma.
Burke, who represented Vasquez in the Dillard's case, disagrees.
Premiums have not gone down. That's the National Council on Compensation Insurance saying only the loss cost portion of rates is down. But talk to people. I insure with a large insurance company. My premium is nearly the same as it was 3 years ago.
And Burke argues Oklahoma businesses are not saving millions of dollars as supporters claim.
If they are saving anything at all, it has nothing to do with the administrative system. It's because of these drastic cuts in benefits. I mean, we had 60% cuts in benefits in many instances. And the poor injured worker in this state is taking the brunt of any cost. The legislature rammed through this law in the last 3 or 4 days of the 2013 session. I've talked to 30 legislators who didn't have a chance to read it. They had no idea that it was giving Oklahoma's injured workers the lowest benefits in the nation.
Burke points out the Supreme Court decision is just the latest in a series of rulings against the new law.
38 provisions of this law have been found either by the Supreme Court or by district courts to be unconstitutional, inoperable, or invalid.
Governor Mary Fallin, who supported the overhaul of the workers' compensation system, says it's too soon to say if a major rewrite of the law is necessary.
I encouraged the legislators last session to look at cleanup language of any questions on our old workers' compensation law that established a new administrative system. So I'm hoping the legislators will look at our current workers' compensation laws to see if there's something we need to do to improve upon it.
Echols says lawmakers will consider how the workers' comp system should be tweaked when the legislature reconvenes next year.
To the extent there are provisions that are unfair for Oklahoma workers, we need to look at those. To the extent there are provisions that are unfair to Oklahoma businesses, we need to look at those. And we need to keep moving the state forward in overall workers' compensation reform.
In the meantime, companies which had written their own plans will have 90 days to obtain coverage through the state's workers' comp system or qualify as an own risk employer.